Hello, my name is Conor Duff and I am the FE1 Contract Law Lecturer here in City Colleges. This will be your night before revision lecture, and there's also some notes that have been uploaded on the website as well for the purposes of your last minute revision. What I intend to do during this brief recording is to just go over some last minute pointers in advance of your upcoming exam, and to go through some of the predictions that I have for the upcoming October 2024 contract law paper. In terms of the contract law paper itself, as some of you will know, the topics are generally mixed for this exam, and we can see in recent times your examiner is quite generous in terms of the problem questions, because they're typically broken down into two paragraphs, and typically it's one or maybe a second discrete issue per paragraph. So they're nicely delineated if it is a problem question. We know also that once upon a time this examiner would have always had 4 problem-based questions, 4 essay-based questions. However, we can see in recent papers that there's a trend towards more problem-based questions and less essay-based questions. For example, we know that usually questions 1 to 7 are problem, and then question 8 is now traditionally an essay question. So essay questions have arisen in terms of the Unfair Terms in Consumer Contracts Directive, undue influence, duress, and in particular economic duress, etc. But now, unfortunately, I would say there's only one essay question in the recent papers. Really, with contract law, you cannot depend on a single issue to come up, and I always advise students as to the dangers associated with playing Russian roulette with this exam. Whilst there is some level of predictability in terms of the favourite topics for the examiner, there is no way that we can say with any level of certainty as to what topics are going to come up in the exam. There are bankers such as offer and acceptance, consideration, discharge of contractual obligations, remedies, mistake, misrepresentation. We do really need to cover a broad range of the syllabus so that we are ensuring that we are well equipped for the exam. I always refer to the example that once upon a time for contract, one paper would be mistake, the following paper would have misrepresentation, and it would work in that formulation. Until recently, in one problem question, the examiner had asked students on mistake and misrepresentation, and that actually came up quite recently as well. So really, this is not the type of exam that you can bet and only cover certain topics. You really need to have a broad understanding of the syllabus to do well in this exam. I would also say that the last paper for this exam, the March 2024 paper, I thought was an exceptionally challenging and difficult paper for students, and I imagine that many students found it very, very difficult to navigate through that exam, and there were some complex problem questions that students would never have typically seen in previous papers. So I am hopeful that the upcoming October paper will be more generous to students and will be more straightforward. As you are aware at this stage, you are permitted to bring in certain pieces of legislation into this exam. You are permitted to bring in the Sale of Goods Act 1893, the Sale of Goods and Supply of Services Act 1980, and then, as of recently, you are now permitted to bring in the Consumer Rights Act of 2022. You will all be familiar that the Consumer Rights Act of 2022 is the recently enacted consumer legislation that repeals and revokes many of the provisions of the Sale of Goods Act and the Sale of Goods and Supply of Services Act 1980 in respect of consumer contracts. And it also retransposes the Unfair Terms in Consumer Contracts Directive and the cancellation and certain other rights of consumers in respect of outside of business premises contracts, etc. So students should have a very good familiarity with parts 2 to 6 of the Consumer Rights Act. For those of you who are reliant upon contract textbooks, unfortunately, I imagine that the majority of them will not deal with the provisions of the Consumer Rights Act. So it is important that you are up to date with that and know that it completely reforms the area of consumer protection for consumers. You may be wondering, well then why can we bring in the Sale of Goods Act 1893 and the Sale of Goods and Supply of Services Act 1980? Well, those two pieces of legislation will be relevant only in the context of business-to-business contracts. And so I would encourage you to familiarise yourselves with the legislation in advance of going into the exam. Now, the other complicating factor at the moment is that the Consumer Rights Act of 2022 is not available from the Office of Public Works. Maybe double check it at the time you're watching this recording, because the official Irish translation has not been completed. So I know for the last two papers that the examiner has permitted students to bring in a printed copy of parts 2 to 6 of the Consumer Rights Act. So hopefully the Law Society will give us some clear guidance on that position closer to the exam. The best way for you to revise at this stage for contract law will be for the use of mind maps. Mind maps are a great way for you to focus for the exam and for you to try and anticipate certain topics and make sure that you have the relevant notes and cases prepared for the exam. So in that regard, I've uploaded there on the slide a sample mind map for the topic of acceptance, and it's just a very, very brief one. They don't need to be as fancy as that as prepared online, but if you just prepare your own jotted notes on certain topics and prepare a mind map for last minute revision, it may serve as a good tool. I have here on the slide certain what I would call hot topics that I would not be surprised to see on your exam paper itself. Of course, I don't hold a crystal ball for the exam. I don't know what's going to come up, but certainly looking through the past papers, these are the topics that I'm telling my students to pay particular attention to for the upcoming October 2024 paper. So I would have particular regard to the topic, I keep saying October by the way, I think it's a September exam, or early October rather. Offer and acceptance, consideration, mistake and misrepresentation, discharge of contractual obligations, remedies, exclusion clauses, contractual interpretation, estoppel and consumer protection. Now that may sound like I'm listing the entire syllabus, but if we take those in turn, offer and acceptance, you need to know the fundamentals. What is an offer? What is versus an invitation to treat? You need to know the circumstances where an offer will be terminated. So the 4 circumstances: revocation, rejection, lapse of time and death. And in fact, that actually came up as an essay question some papers ago. Describe the 4 ways in which an offer can be terminated. You really need to know rejection and revocation really, really well. So make sure you pay particular attention to that. Consideration then is also a very popular topic with your examiner. Know your fundamentals of the law relating to consideration. Know the rule against past consideration. Know the rule in Williams and Roffey Brothers and the case law in respect of that. And then also know the rule in Pinnell's case, which again could very well crop up on your paper. Mistake and misrepresentation are always favourites of your examiner. As I mentioned to you earlier on, they traditionally came up 1 per paper. In the last paper, both of them came up in a single question. And in fact, I think misrepresentation came up in a second question. So you need to know those 2 topics really, really well. Know a good number of cases for it. Know your fundamental principles of it and be able to explain what each of those topics are. Discharge of contractual obligations is of course another popular topic. We saw frustration come up in the last paper, and it's definitely a topic that you need to know well going into the exam. Contractual remedies, similarly, that's a very large topic. You need to know that very, very well for your exam. You need to look at damages. You need to look at damages for emotional distress, liquidation and penalty clauses. There's a topic, penalty clauses came up in the last paper. Remedies is one of the favourites of your examiner. Now I've put 3 stars beside the next 3 topics because I think I would really not be surprised to see them come up in your exam. Exclusion clauses is another favourite of your examiner and has come up in many, many papers. It didn't come up in the last paper, and I think it's due a run in your upcoming paper. It lends itself more towards a problem-based question, so definitely look out for a question on exclusion clauses. I would not be surprised to see that come up in the exam. Contractual interpretation, also, that has not come up in a long time, and I think it is certainly due a run. There's a lot on it. There's a lot of recent case law in respect of contractual interpretation, so students definitely have a lot of case law for that, and be able to talk about the contextualist method of interpretation, and be able to refer to your stock cases, the Law Society of Ireland and the MIBI, the modern principles in ICS Bromwich, Jackie Green construction, some of the recent case laws such as Hyper Trust Limited trading as the Leopardstown Inn versus FBD Insurance, Brooksfield, the Clarency Hotel, all of those recent cases that will be able to show to your examiner a high level, intimate knowledge of recent cases in contract law. So it's important that if you do have any recent cases that you can refer to, that you do refer to it in the exam, because you're showing your examiner that you have a really up-to-date understanding of the subject. And the examiner has in fact been quite critical in recent times of students referring to outdated materials. So it is important that you're able to refer to recent case law. Estoppel then is another topic that I think is due a run. Don't ask me why, it hasn't come up for a while, so I think it is definitely due a run. And then consumer protection. Given the recent enactment of the Consumer Rights Act of 2022, the examiner has kind of been slowly feeding it in, and in the last paper we got a really nice problem question on the area of consumer protection, and I think that trend will most certainly continue. So I would definitely be expecting a problem question. I think it'll be interesting to see whether we get an essay question on the impact of the new Consumer Rights Act or how it changes the law. I think that would be interesting, but again, I think it would be nearly guaranteed to be on your paper. So hopefully some of those predictions come up for the upcoming exam for you. And I give a breakdown here of the most popular topics over the last 25 papers, and you'll see there the trends on the slide as to what are the kind of topics that we see come up time and time again. In terms of the March 2024 paper, I don't think there are two ways about it. A lot of our students did very, very well. I thought it was really a horrible paper, if I can call it that. I thought it was very, very tricky. I think it presented lots of challenges to students, and I think it was a very, very challenging paper for students. So I do hope that there were some kind of bankers that came up offering acceptance, misrepresentation, mistake, unfair terms has been a favourite of the examiner for a long time. Consumer protection obviously is to be welcomed, but there were some really tough questions there. I thought the question 1 and question 3 were very, very challenging for students. I thought 5 was challenging. 7, frustration came up quite a lot during the COVID-19 pandemic. I thought it had kind of gone to bed, but it did come up in the March 2024 paper. So students would have been very, very well prepared for question 8, which was the essay question on unfair terms. So they would have welcomed that, but there were many, many challenges with the March 2024 paper. And then I don't want to go through it and take up your time, but there on the slides which are available to you, the breakdown in some previous papers, October 23, March 2024, and so on. So you can look at those and see trends that you think might come up. Undue influence is perhaps something I've left off the list that probably should be on it as well. That is definitely due a run, and I would probably have a little look at the question 2 from March 2023 as well in that regard. I also, as I mentioned earlier on to all of you, spoke of some recent case law, and there's many new cases, and I really highlight these to my students as we go through the course, but here is just a select sample of some cases between 2020 to 2022. I think I go so far as here. Hyper Trust Limited trading as the Leopardstown Inn and FBD Insurance. This was obviously the very big case concerning contractual interpretation and the interpretation of a clause in an insurance contract regarding the outbreak of contagious diseases. And Mr. Justice Dennis MacDonald reaffirmed the contextualist method of interpretation that we use here in Ireland. EBS and Ryan was a relative-ish decision of Mr. Justice Max Barrett in the High Court regarding unfair terms in consumer contracts and its applicability in that case in respect of an appeal of a Circuit Court order. Oyster Sugars Limited trading as Claw versus Architecture and Manufacture Support Limited and another. Again, this was a relatively recent judgment, by Mr. Justice Sanfi of the High Court regarding a claim made by the plaintiff restaurant Claw of partial frustration, and the court again emphatically rejected any contention that there is a claim of partial frustration known to Irish law. Similarly, that was the case in Footlocker Retail Ireland Limited and Percy Nominees about the Footlocker shop on Grafton Street. London Trocadero versus Picture House Cinemas was an interesting case in the UK High Court regarding whether there was an implied term in the contract that the rental payments would not be due during the pandemic, and that was rejected by the UK High Court, but nevertheless an interesting point that was raised. And then the other 2022 case there, again from the UK High Court, is the Football Association Premier League versus PP Live Sports International. And that was another contractual interpretation case about the package that was entered into between the parties regarding match highlights, or the clippings, or the snippets I think they call, or highlights rather, and football matches during the COVID-19 virus, when there were no matches or there were limited numbers in terms of the crowds. So none of them are really a restatement of the law, or a change of the law rather. They're just another source of confirmation of the legal position. What's really important for the contract law exam, more so than any other subject that I teach, is the importance of structure. And I've been saying it for a long time that students really need to focus on using the ILAC structure for problem-based scenarios: issue, law, application and conclusion. And particularly with application, that is an area that has been consistent, in fact, say for the last examiner's report, that the examiner consistently is beating the drum that students need to apply the law to the facts presented in the problem question. So it's really, really important that you're taking time in the exam to apply the law that you've just discussed to the facts of the problem question. So please do remember to take time to apply the law to the facts. The examiner again is highlighting in her reports that students are effectively regurgitating their notes and everything they know off by heart without linking it to the question, and also giving unnecessary detail regarding case law. So when you're referring to case law, you really have to highlight the important, pertinent provision of the case or point of the case and move on. You don't go into too much detail regarding the facts of the case, okay? Because you're not being asked or examined on the facts of each one of the cases. You really need to identify the ratio of the decision and be able to move on. The best way I teach contract law, and the best way for you to revise it now, is to look at the birth of the contract through to the life and finally the death of the contract. And a good tip in the exam is when you're reading a problem question and you may be confused as to what the topic you're being examined on is, it might be helpful for you to ask yourself, where in the life of the contract are we? And that may be a good tool to identify what the relevant topic is. So thank you all very much for your attention. I hope you found this short video to be helpful for the upcoming FE1 contract law exam. There are notes as well online available to you for the last minute preparation. So the very best of luck, and thank you very much.